Assalamualaikum warahmatullahi wabarakatuh and a very good afternoon to all. Before we proceed with the explanation about this case, can you imagine if one day someone is entering your property without your consent and claims that their behavior is lawful in some circumstances? So this situation relates to the case of Armugam anak lelaki Letchumanan and Tenaga Nasional Berhad TNB in the year of 2011. This case was held in the High Court of Kuala Lumpur on 31st of August 2010. The plaintiff of this case is Armugam anak lelaki Letchumanan and the defendant is Tenaga Nasional Berhad TNB. In this case, the defendant was alleged to have committed trespass. The plaintiff's land is Lot 5, 6, 0 and 9, which part of a Felda settlement area called Felda Sungai Kelah developed in the year of 1969. So, the plaintiff was a settler under the Land Group Settlement Areas Act 1960 Land GSA Act of the land, claiming that the defendant committed a tort of trespass and nuisance that caused the infringement of the plaintiff's land. It was reported that the Menara C trespassed 6 feet onto the plaintiff's land and the transmission line was 11 feet from the base of the plaintiff's tower. So, the employees of TNB also regularly cross the lot to maintain the 3 towers, which towers A, B and C. TNB also illegally entered the plaintiff's land from 2003 to 2005 and moreover TNB committed another trespass by cutting the trees on the plaintiff's land. For the compensation, the defendant claimed that they had already paid the compensation to Felda, not directly to the plaintiff. However, the plaintiff claimed that he only received Rm 2,520 ringgit and had not fully participated in the year of 1981 inquiry. The defendant questioned the ownership of the land that was trespassed because in the year of 1981, the plaintiff had not registered title. The title was only registered to the plaintiff in the year of 1996, after which he argued that any entry without permission became illegal. On the other hand, TNB referred to the Section 52 and 53 of the Electricity Act 1949, claiming that the LLN did a lawful act in 1981. However, the plaintiff disputed that the required notice under Section 53 was served him, held by the collector of land revenue in Tapa. The plaintiff argued about the ownership of the land. He claimed that the act of the defendant was unlawful in the year of 1996 in accordance with the Article 13 of the Federal Constitution.
For the first legal issue, we want to know whether defendant had actually committed trespass under the tort law by erected on Menara C on plaintiff lot. So right now, we will discuss on the counsel argument, particularly for the plaintiff. So what plaintiff claimed first is that plaintiff said TNB had trespassed his land by building Menara C in 1981 and maintaining transmission line without his permission. A qualified surveyor, SP2, confirmed that Menara C was 6 feet into lot 5609 and the transmission line was 11 feet over it. The plaintiff say that trespass is still happening because TNB worker keep on entering his land without his permission to maintain Menara A, B and C. The plaintiff lawyer argued that they do not receive any information or notice that is properly given to them before using the land as required by the Section 53 of Electricity Act 1949. He claimed that TNB also cut down the plaintiff tree in 2003, 2004 and 2005, which plaintiff said that it was illegal and added to this trespass claim. So right now, we will look what defendant say and what defendant claim on the legal issue for the first legal issue. For the first one, defendant said that at that time, Felda Sungai Kelah was still under the state land under Felda control and settler did not own the land yet because they have no land title to the issue. TNB also showed letters proving that Felda gave permission to build Menara C and accepted compensation on behalf of the settler. TNB said that on the Section 52 of Electric Act 1949, it was allowed to enter the state to build power lines without the need of permission from individual settler. TNB also said that based on Section 37 subset 12 clause A on the Electricity Supply Act 1990, it had to cut down trees over 8 feet long in the transmission area to prevent electrical hazard. In 1981, the land official, which is the land revenue collector, had properly investigated before giving any compensation. Since the land had not yet been officially given to the settler, it was fair for Felda to receive the payment.
Moving on to our first legal principle that derived from this issue is that a person only can sue for trespass after they become a lawful owner of the land. However, after the owner gains a legal title of the landowner has exercised full exclusive rights, and any subsequent unauthorized entry, occupation, or interference with the land by another party may amount to a fresh or continuing act of trespass. Plus, the landowner is entitled to seek remedies for any trespass, including injunction or damages, if the entry or use is not justified by a valid statutory rights or consent. Moving on to our ratio decidendi for the first issue. In this case, the plaintiff could not maintain a trespass claim for acts occurring in 1981 because the land was at that time state land vested in and administered by Felda under the Land Group Settlement Areas Act 1960. However, after the issuance of the title in 1996, the plaintiff became the lawful proprietor. Therefore, any unauthorized entry, interference, or true felling by the defendant after the date and outside the scope of any existing statutory right of way amounted to actionable trespass. As for the year 2003, 2004, and 2005, a claim for trespass could not be made since LLN had lawfully obtained a right of way in 1981 to erect the Menara C on the plaintiff lot under the Electricity Act 1949. As our decision for the first legal issue is that the court dismissed the plaintiff's claim for trespass in relation to the 1981 construction of the transmission tower, as the land was still a state land administered by Felda, and the plaintiff had not yet acquired a legal title. As for the years of 2003, 2004, and 2005, a claim for trespass could not be made, since LLN has obtained a right of way in 1981. And that's the end of the discussion for our first legal issue.
So for the second legal issue is whether the plaintiff is entitled to claim additional compensation and damages from the defendant under the Electricity Act 1949, despite compensation having already been paid for the felling and lopping of trees within the road of Menara C. Alright, so let us now moving on to the second issue for the counsel argument. Let us start with the plaintiff first. The learned counsel of the plaintiff argued if the court decided to hold the investigation by the collector of the land revenue on 27 January 1981 is valid. The plaintiff stated that the compensation made by defendant is inadequate since the validity was decided by the plaintiff itself, and he also has a right to consider the adequacy of the compensation made by the plaintiff. The second one is in the case of Tenaga, Nasional Berhad, and Ong Si Tiong and another, the plaintiff suing themselves and on behalf of the owner of Kampung Sungai Terendang in accordance with the serve notice under Section 13 and 16 of the Electricity Supply Act 1990. Also, the defendant is not allowed to claim the compensation owed by them according to Section 52, 53, 54 and 58 under the Electricity Act 1949, which Section 53, 54 and 58 is aligned with the Section 11, 12, 16 of the 1990 Act, which is the Electricity Supply Act. However, any less compensation that doesn't reach the adequacy will be owned under the Land Acquisition Act. The defendant argued, Ong Si Tiong said that the adequate compensation is when it is made to the person affected by the acts, and the findings in Oakfield Enterprise Sendirian Berhad as decided by High Court and also Court of Appeal cannot be relied upon. A new village is located along the route of existing 30K transmission line. The owners and residents of the new village objected to the proposal. In June 2007, TNB served a notice under Section 13 of the 1990 Act. In response, the applicants filed a judicial review application in High Court. This is for seeking revocation of the appellant's decision to issue the notice. The applicants requested to have the notice declared as null and void. Moreover, the applicant also applied an injunction to stop the TNB from continuing the work under Section 13 of the 1990 Act. They allege that TNB, under justification of upgrading existing transmission line, has attempted to enter the land with a hidden agenda to acquire without offering any proper compensation for such acquisition. So the last one is that the plaintiff, based on their claim on section 44 clause 1 of the National Land Code, the plaintiff further argued that section 52, 53, 54 and 58 of the 1949 Act are unconstitutional as they failed to provide fair and adequate compensation in line with the Article 13 of the Federal Constitution. Article 30 clause 2 of the Federal Constitution clearly states that no law shall allow for the compulsory acquisition or use of the property without an adequate compensation. So that's all for plaintiff. Next, we're moving on to the defendant. For the second issue, the learned counsel for the defendant argued that LLN, Lembaga Research Negara, TNB's predecessor, had already obtained a lawful way for the compensation process to the plaintiff. According to Saksi Defendant 3, the process of obtaining involvement, the given notice also stated that collector of land revenue would hold a hearing to decide any compensation. Also, Saksi Defendant 3 also informed Felda LLN will pay compensation to Felda or based on Felda's advice to the settler themselves for any damage to property caused by this construction. The compensation will be assessed by the collector of the land revenue where the land is located. Next is Felda agreed to LLN request to build the transmission line Menara on the condition that settlers will be given electricity supply and 30 ringgit will be paid for each tree cut down in the Felda Sungai Klah according to the section 58 of the Electricity Act. Next is a letter dated 26 May 1979 from Felda confirmed that it had no objection to LLN building, and also Felda was paid 30 ringgit for each rubber tree cut in Sungai Klah. Felda was also told that it could appeal the compensation amount if unhappy. So number 5 is TMB argued that any further tree felling with the rentiers, there will be no further compensation in any event under the provision to section 58 clause 1 of the 1949 Act. No further compensation shall be allowed or payable for felling or lopping of trees after the payment compensation under section 52, 53 and also 54. So that's all for the counsel argument for the second issue.
The legal principle for the second issue is one, compensation has been paid under the Electricity Act 1949 for installation and damage like cutting down trees. No more compensation can be claimed later for maintenance work on the same path. The ratio decidendi for the second issue is LLN paid compensation to Felda under Electricity Act for all disturbance including tree cutting. The plaintiff later received part of this compensation for Felda, so he can't ask for more. The law, which is under section 58, clearly states that no extra compensation is allowed after the first payment for things like tree felling. Even though the plaintiff didn't get a formal notice under section 53, it wasn't needed because at that time the land was belonged to the state and Felda was in charge. The compensation legally paid to Felda, who represent the settlers. The court decision for the second issue is the court has rejected the plaintiff claim. He got ownership of the land only in 1996, but the trees were cut in 1981. Since Felda was already compensated back then and part of it went to him later, he's not entitled to any more payments.